to order, and I see we have a quorum with Klein, Johnson, Fredericks, and myself are here. Now, before we get started, we got a request from member Solner. He would like to come to the board remotely, and he has filed the correct notices with the office, Solner. And does anyone have any objection to member Solner joining us by phone? I see no objections, so welcome aboard, Jim. First item that we have, the first item that we have is the minutes from the last meeting from December. I'll entertain a motion for that. Motion by Johnson, second by Klein. And any additions and corrections to the minutes? Seeing none, we'll vote on that. All in favor of the minutes, say aye. Aye. And the second thing is a recommendation. I have a recommendation from the auditor. She has reviewed the bills, and we have bills in the amount of $1,446.75. And she says they're all okay to be paid. I will entertain a motion for that. A motion from Fredericks, seconded by Johnson. And any questions on that? If not, all those in favor, say aye. Those against, say no. Okay, now we've got 4 items for action today. We've got 5A, which we'll take separately. And this is a request for approval to initiate amendment to Section 350-55 of McLean County zoning ordinance pursuant to Section 350-21B and C of the McLean County Code. I will entertain a motion to that. Motion by Johnson, seconded by Fredericks. Any discussion? Phil, would you like to explain that to us?
Well, it isn't really my action item, but I have some questions I'd like to ask about that, if I could. In the communication attached to the proposed text amendment pertaining to that Sapphire Sky wind farm, you're proposing additional notification requirements for impacted occupied residents with a significant number of wind turbines surrounding their property. Do you have an idea of how many of these residences there are that have turbines within at least 5 turbines within that mile?
This is not in any way related to Sapphire Sky. This is in the code. So it's not pertaining to any, this will go into code after Sapphire Sky has received its approval. So this would be for future projects.
I do understand that, but you mentioned in here that this came from discussion of that.
Yes. Well, hypothetically, I mean, Lizzie can answer too. Hypothetically, we don't know which the next contract, the next company, what they will ask for. So I don't know that there's any way for us to understand or project a certain number. But there were instances in this past case where we thought this level of added notification would have aided in sort of smoothing the process with some of the landowners who were unhappy and asking for changes at the last moment.
So you think there were a lot?
I'm not sure that there were a lot, but I don't think this is a significant burden to bear, even if it's 1 or 2 households, in my opinion. A certified letter isn't a terrible burden, and from my perspective, even if it's one or two households who would find themselves somehow unaware of the fact that a neighboring property would have that many turbines near their property line.
Excuse me, I'm sorry to interrupt. Did we skip number 4, appearances by member of the public?
We have no requests to appear by members of the public, if I could address number 4.
Oh, yeah, yes, yeah. Grab that.
Thank you.
A second question I have is, how are residents negatively impacted by having turbines 3/4 of a mile from their house?
So as far as the kind of the reasoning of why we chose to do it this way is that in watching the procedures last year, there was sufficient concern that the ZBA gave special authorization, special kind of dispensation for a few of the homeowners who came forward and had a problem with the number of towers. And that was well within their ability to set that rule. The bigger concern that I had was that we had people that found out after the fact that that was an option and tried to come to the county board to get more approvals, to get more exceptions made. And so if, considering that the ZBA felt that 6 was an excessive number, we felt it would be an appropriate accommodation for anybody who is submitting for a special permit to be able to contact anybody that had that number of towers within a mile of their house to be able to come and petition. Because we know in this day and age, posting in the newspaper meets the letter of the law, but not everybody reads that. And so we wanted to make sure that anybody that was in an occupied residence, all right, an occupied place, that the owners had sufficient notice to be able to get here and to either make requests or to not show up and not ask for anything if that's not what they care, if they didn't care, but at least they had the knowledge for ones that the ZBA had determined that's an excessive number of towers.
So you don't have an answer to that question? You don't have an answer to the question that how are property owners negatively impacted by a turbine 3/4 of a mile away?
No, I do not have a specific answer for that. I think the question is not actually relevant insofar as what we're not saying that this is simply for notification so that they are aware. This doesn't judge positively or negatively what they're going to feel about having that many near their property. They may be participants as well and not care at all because they've got 5 on their property, but this is just for notification. So this isn't implying that having more than 5 within 1 mile of your house is a positive or a negative thing. Simply that if there's a mass amount, that number or more near a residence, that you be specifically notified so that you can object should you feel that that's a problem.
Are you aware that everyone receives a notification? All these property owners that are within 250 feet of the wind farm?
The letter of the law states that the company only has to put it in the paper. So we're simply putting into code that that's not, the minimum isn't, that's not acceptable to us. The minimum is that they have to send a certified letter. If a company's already doing that, then that's great. But we want to put it into the code that at least be the minimum.
We send out hundreds of notices for every wind farm. Are you aware of that? To property owners?
Yes, but this is putting the burden on the company.
How would the county enforce this notice requirement since we don't have precise locations of turbines when the WEX applications are submitted?
Well, we have proposed locations, and we can act on that. And then, of course, the company, if a person objects, then the company can shift the location. But when they come with their application, they have a proposed layout.
I'm not aware of that.
to my understanding, that's what it was with Sapphire Sky, and that's why certain individual landowners raised objection, because they wanted to be, they did not want those turbines near their home. So this was my understanding.
How is a notice sent by certified mail a better way of communication than a notice sent by first-class mail, in your experience?
Yeah, certified mail, we know that it's gotten into the hands of the owner of the occupied residence.
Only if they go to the post office to pick it up.
But they have to sign for it to get it.
Yeah, certified mail you have to sign for.
But if they don't sign for it, they don't get it. If they don't go to the post office to pick it up, they don't get it.
Mhm.
Okay.
Any other questions? Let's see. Well, all those in favor, say aye. Those opposed, say nay. I think the ayes have it, so it passes. Now, we've got items B, C, and D. Are those, Phil, are those all to do with the farming? Okay, well, all right, well, let's take B. Request approval of a initial amendment to section 350-43 of the McLean County Zodian Ordinance pursuant to section 350-21B and C of the McLean County Code. I'll entertain a motion for that. Fredericks and Johnson second. Now, is there any questions? Any discussion on that?
If I could just do a friendly amendment, there's a typo. It's pasture. There's an extra R in that word, so if we could, that's on the fourth line of L. It's pasture, meadow,
And yard.
yard, or land tracts. So there are two typos, so it's just be a friendly amendment for the Scrivener's error.
All right, well, I'll accept that, I guess. Do it. Any other questions on this? If not, we'll take a vote. All those in favor, say aye. Aye.
Aye.
Those opposed, say nay. Motion passes. All right. C and D. Item 5, C and D, request approval of the initiated amendment to section 350-26 of the McLean County Code, amending the definition of a farm as required by the Executive Committee of the McLean County Board. And D is request approval to initiate amendment of section 350-21 of the McLean County Code zoning ordinance, clarifying the authority of the Land Use and Transportation Committee to initiate requests for amendments to the McLean County zoning ordinance. And I'll entertain a motion for those two together. Johnson and any discussion on that? If not, we'll take a vote on that. All those in favor say
I
aye.
have a question, sorry. I just wanted to clarify what we're actually
Oh.
doing. So we passed this before, and I think several of us had questions because we thought that the wording that we passed was actually supported by the Farm Bureau, but then we learned it wasn't. So I just want to be clear about what we're voting on. We're voting on keeping the word farm, but deleting 40 acres or more in size. So last time we had voted to eliminate farm also, but this time we're keeping that in. I just wanted to make sure I'm clear.
Phil,
Is that
do you have any
correct?
Yeah, I
comments
think
on that?
I tried to explain it as well as I could in this memo. And that was that when it went to the executive committee, they thought that it may not be a good idea to take the definition of farm out of the ordinance completely because it might be referred to in other parts of the ordinance. And so they wanted to leave the definition of farm other than that a stipulation about 40 acres and just leave that part out. And it's our understanding that that 40-acre part of it is what the Farm Bureau, McLean County Farm Bureau, wanted to be deleted from the ordinance.
Okay. Any other questions?
Mr. Chairman, can you hear me?
Oh, Jim? Yeah, go ahead.
Yes. I was wondering if Ms. Ziegler from the Farm Bureau was there, and if this meets with their approval. I don't know how we can communicate with her.
I'd like to second that, to ask her to come and speak.
Yeah, all right, yeah. She can come up and explain what.
Go right beside Lizzie there.
Yeah.
Okay. Hi there. Do you need me to say my name or anything?
Yeah, go ahead.
All right. Well, thank you. I appreciate the opportunity to speak. I apologize that I didn't apply to speak in advance. I was wondering if this was the appropriate venue or if I should wait till it actually goes to the zoning board to speak to it. We do agree. We would like to see the farm definition stay with just the acreage part removed. However, there's a second part in section 350.26 definitions under agriculture, part B. There's also reference to 40 acres in that definition, and we believe it should be removed from that definition as well.
So she's found in another place where they use that.
Yeah,
That
it's not in your
acreage.
packet.
Oh,
It's not
okay.
in your packet. You'd have to look at the actual, you'd have to look at the zoning ordinance.
So we need to change two things. I mean,
Yes, we believe that.
But we may have to come back
We
through
believe
one
that
more
this
time.
second definition also would be in conflict with state law.
okay.
But again, we're not at a zoning hearing. It may not be appropriate to change it here. It may not, I don't want to speak out of turn.
You know, if that conforms to what we need to do, we take an amendment to this.
Yep, I think the state's
I'll
attorney
entertain
wants to
it.
say something.
Yeah, go ahead.
So, first off, let's set what happened here. The Farm Bureau brought this to our attention because of and correct me if I'm wrong, Ms. Ziegler, but because of an Attorney General opinion that basically says that we shouldn't have a size requirement on it, correct?
Correct.
The second section of the code that you're referring to now does not impose a size requirement, except that a condition that if the farm is less than 40 acres, then it has, and I don't remember this off the top of my head, and I didn't pull it out exactly, but then it has to apply for certain exceptions. And I believe in my discussions with Mr. Dick, we thought that that was an appropriate section to leave in under the circumstances. Otherwise, you can have what amounts to a farm. And you can at least then, it doesn't mean that it's going to be denied based on the size. It only means that if the size of the farm is less than 40 acres, there has to be an application, and then it would be looked at that way for other factors, not the size of the farm. So I don't believe in any way that the second section you're referring to violates the Attorney General's opinion. It just adds a different layer for analysis. And you probably have the language right in front of you. You can correct me if I'm wrong. Mr. Dick knows what I'm talking about too. We had this conversation, and he might have some more information on that.
Phil, do we need an amendment to this to include that or not?
I don't know that we need that amendment.
Okay. Well, then we won't have an amendment. Now, is there any other questions on that?
No, I just wanted to ensure that the amendment that we are getting ready to vote on, does that meet with the Farm Bureau
Yes,
preference?
Yes.
Okay,
that portion does.
okay, all right. That's what I understand. Thank you very much.
Yep.
Well, I think then this goes to the executive committee, so if there's any problem with it, Phil can get it straightened
And
out.
it still has to
then
go through a zoning
between now and
hearing as
then.
well. Yeah, so there are further
Okay.
opportunities
Any
to
other
discuss it.
questions on this? If not, we'll take a vote. The chairman will vote. All those in favor? Aye. Those
Aye.
opposed, nay. It passes. Now, let's see, I think. Oh, Cassie Taylor. Oh, wait, no, we don't have anything from her. Let's see. Monthly report. And our next meeting is 3:30 Thursday, February 3rd, 2022. And yes,
I've got one more comment. So, the next meeting will be, 3:30 on Thursday, February 3rd, and then your March meeting will be your combined meeting with transportation, where you have the new Land Use and Transportation Committee, and that will be held at 8 a.m. on Tuesday morning
okay, the March meeting will be.
in the
then.
March meeting.
Will we be informed of the membership, or is just everybody gonna be one giant committee?
You will be informed of the membership at the February meeting. There will be changes to committees as well as the assignment of the replacement of the vacancy left by Lori Woolrab leaving the board.
Any other questions? Any other comments? Are we done? Then we can be adjourned.